Abuseni como all channel so haksi AGH Politics Avenue podcast or certain me kusibeki headlines and a jumbre na yidi bi exomo ni dem ya hobraxi mu se ende yidi di kanya subscribe to the channel famami na yembo enra eye high court na eye attorney general any office of the special prosecutor a kisi jabin eda omu anono onua nseme esi wo court ho nyina onua drama wo mu nyina no onua renowned private legal practitioner bia na oho bi agemre eboye nchiremu asem no from A to Z onua ehu be hia se yedi bi eksomwa eso hu de ekwa ene de eba yemo ngura nseminim na yemfamu aba chena so am se ahase AGH Politics
declared void every conviction secured by the Office of the Special Prosecutor. The court also ordered the Attorney General to take over all criminal trials the OSP is currently handling. The judge ruled that the OSP failed to get the Attorney General's authorization to prosecute, a requirement under Act 959 of the law that set up the office. The decision has ignited a controversial discussion over the OSP's powers and whether Parliament illegally gave the OSP independent powers. Well, my colleague Kwekwa Sante has been combing through the judgment of the High Court, which we have received, in fact, the full ruling, and he joins me in the studio with more. Kweku, interesting decision by the judge. We're just finding out. Let's go into the details of this ruling.
The sticking point that we are getting to know now, we know that it was on Wednesday that the High Court gave this judgment, and since then we've been waiting for the full report to be able to get the details of what exactly Justice Nyadu Nyante said in the judgment, and now we have it. And we know that, contrary to what we knew on Wednesday, that this judgment is far-reaching than we actually thought. In fact, on Wednesday, the reports were that the special prosecutors were simply to hand over all the cases to the Attorney General's department, for that department now to take over, and a declaration that the OSP needs the authorization. But now we know that is way more than that. If you look at the judgment, the full judgment, the big need that we have now is that every single prosecution, if it was successful, that has been conducted by the OSP, is now void, which means it has to start afresh. And let me read for you the specifics of what this judge wrote in this 26-page test judgment. It says, since by clause 3 of Article 88 of the Constitution, the Attorney General is responsible for the initiation and conduct of prosecution of all criminal offenses in Ghana, I hereby order the Attorney General to take over all the prosecutions currently being undertaken or being handled by the OSP, pending the OSP applying to the Attorney General for authorization. This is what we knew on Wednesday. And then consequently, any convictions, if any, secured by the respondent Office of the Special Prosecutor as a result of the purported exercise of prosecutorial powers is hereby declared void. And I order the trial of the persons so convicted to be commenced afresh by the Attorney General, pending the respondent, that is the Special Prosecutor, applying to the Attorney General for its officers to be authorized to conduct criminal prosecutions and the issue of the necessary executive instrument in that regard. So, Faustina, very, very far-reaching recommendations.
And then the big question now is that the Office of the Special Prosecutor, have they even secured any convictions so far? What are the implications moving forward?
Well, if you look at the Office of the Special Prosecutor's website, there are some details of convictions. And we know that since the establishment, 33 people, at least up until the last count, have all been put on trial, with 10 cases currently at various cities, at the various high courts. And then 7 convictions have already been secured. In fact, 7 convictions in terms of 7 persons, because if you look at it in details, there are 2 convictions. When it comes to convictions, one involves Andy Thomas Owusu in the case of the Republic vs. Charles Bishu, and another, which is a tax force-linked corruption allegation in the illegal mining space. This person admitted to taking bribe to help bypass the process for securing a mining license and was fined and ordered to pay money back to the state. The other 6 has to do with some people who were convicted internally by the OSP because they actually signed on to a plea deal, and they were convicted on charges of corruption, false certification, and causing financial loss to the state. These are all convictions that are now void as per Justice Nyadu Nyante. So if anybody is in jail right now, by virtue of the special prosecutor having gotten a court to convict them, they can simply get their lawyers, they'll file an application, the next morning they are walking home. If you have been asked to pay a fine, if you paid it, you can go back to the state and take it because the trial has...
But what if, like in the first case scenario you painted, the individual actually admitted to taking the money?
Yes.
Still?
But because
doesn't apply?
It is the fruit of the poisonous tree, you are going to start again. And so it is as though the trial did not even take place. The Attorney General will now start afresh, take the plea of these persons, they will go back to court and make the same argument. If this time around, this person pleads guilty, that is fine. If he decides to now mount a robust defense of himself, the case will drag on. So it is a judgment of really seismic interventions that we are seeing from Justice Nyadu Nyante. And of course, we must say that the OSP has said that he strongly disagrees with this. It's already filed or working to file an application at the Court of Appeal or perhaps in another way to the Supreme Court to get a court to quash this. But since it has not been quashed, the Attorney General is speaking tough, and we know yesterday they've already announced that they're going to take steps to actually take over all these cases that are being handled by the OSP. And now the big bombshell that certain people who have been convicted will all now have to walk free, at least for now, pending the AG taking decisions on restarting those trials. And
I know that the OSP actually rejected that stance by the judge, saying that it was a matter of constitutionality. Looking at this judgment now, what then makes of his defense?
In fact, when this matter came before Justice Nyadu Nyante, one of the arguments that the special prosecutor and his lawyers made before the court was the fact that the reliefs that were being sought were constitutional interpretation in nature, and that the judge ought to stay proceedings and hand it over to the Supreme Court to actually make a determination on Article 88. Justice Nyante disagreed strongly. According to Justice Nyante, if you look at Article 88, it admits of no ambiguity. The only time a judge, and he cites a plethora of cases where a judge would have to put on hold a trial and actually go to the Supreme Court, is when the two parties have put rival meanings to the understanding of a certain provision in the Constitution. One. And that the judge also agrees that if you look at the facts in issue, there are real interpretative issues that ought to go to the Supreme Court. Justice Nyante disagreed, insisting that Article 88 is so clear, you do not need the Supreme Court to interpret a position that is so manifestly understandable by anyone. And so he did not accept that position by the special prosecutor. He rejected that objection and proceeded to rule. But the OSP says it's going to go to the Supreme Court already. Noah Ephraim Adamte also has a case at the Supreme Court bordering on the same and related to the issue. So we'll get to see what the Supreme Court will do. But this is important because the Supreme Court will have to expedite this hearing. If they do not, and this case drags on, like some cases can drag on at the Supreme Court, let's say take a year or two, they're going to have a OSP that cannot do anything really. Because now you go to court, everybody will tell you that there's a court judgment that says you did not have the power to prosecute.
But if they secure at least some sort of authorization from the Office of the AG, they can proceed with other cases pending before them.
In fact, in the subsequent sounds you play of the Attorney General, the Deputy Attorney General, he actually makes the point that they are there. If the OSP is to write to them this afternoon requesting for authorization, they will grant it, of course, subject to the relevant terms and conditions that would have to come with it. But it appears the OSP, according to the Deputy Attorney General, has taken a certain position that he does not require authorization from the Attorney General because he's independent of that office. So there's a therefore sort of brewing between those two anti-corruption institutions.
Thank you so much, Kweku Asante. Well, meanwhile, the Deputy Attorney General, Dr. Justice Ramsai, insists the court acted within its jurisdiction in making the orders. On Wednesday, we told you that the Attorney General's department announced that it is taking steps to assume full control of all the cases under the Office of the Special Prosecutor. Dr. Ramsai has been explaining how that transition will be carried out in coming days.
How does the Attorney General compliance with the law? Okay, Parliament made a law and says the Attorney General should do X, Y, Z, should appoint somebody, should nominate somebody. The Attorney General complies with the law to have that done. How is that an immunity to question of constitutionality? So what kind of argument is that?
Justice, I want to know also, in your post, you are specific that you are taking steps to take over all the cases. How are you going to do that And when are you doing that?
Okay, so as I indicated, I said in the coming days, so we are, since the decision was given and since we got a copy of the decision, we have been having meetings with our officials and we've been planning what to do. And I think that's why I said in the coming days, we'll announce to the public the steps that we are putting in place to ensure that the court, the court's order is given effect to. And to assure the public, let me give this assurance to the general public. Issues of this nature, okay, requires persons who have deep public interest at heart, people who have the mentality to achieve what is right. And we are going to balance every possible interest to ensure that any step that we take to comply with the court decision is taken in the best interest of the people. It is taken with respect to the human rights of the people who are being prosecuted, who have been prosecuted. A high court ordinarily, faced with an application on a particular matter, will make orders to affect that particular matter. But when the particular matter is a question of someone's public authority, and that question has been answered, it goes to the public authority's foundation, not the accused person. So the question before the court is whether you have authority to conduct prosecution, and you are given an opportunity to show that you have the authority to conduct prosecution, and the court found out that you were not able to show that you have authority to prosecute. What other order should the court make that your lack of authority to prosecute is only in respect of this person, but when it comes to another person, even though you still don't have the authority, you will go and prosecute that person?
Sir, but because this was just a single matter, the authorization to be shown had to do with this particular matter. I'm not sure Justice Nante was aware whether or not the OSP has authorization in any of the other cases he's prosecuting. It was limited to this particular case before him. And so there are those who suggest strongly that he had to make orders that bordered on the specifics of the issue before him.
The court found that the OSP did not have authorization to prosecute at all. So you want the court to say that even though you don't have authorization to prosecute at all, you can prosecute some other people, but you can't prosecute this person before me. In other words, you expect that even though the finding is that there is no authorization at all, every other accused person should go and then file a different case for the court to go through and come to the same conclusion, and for the court to come to the same conclusion. So the issue of having decided a case which doesn't apply to another case depends on the nature of the inquiry before the court. It is not a general rule that when the court is making a decision in respect of one person, and then he cannot make the decision will not go and affect the other person. If the question is about the person's authority and the finding is that he doesn't have the authority, on what basis would the court say that go and prosecute other people?
Well, the Deputy Attorney General says the AG is open to authorizing the OSP to prosecute, but the Special Prosecutor holds the view that his office is independent of the Attorney General and does not require authorization.
This government understands the essence, the importance of the Office of the Special Prosecutor. We have no intention or desire to shut down the Office of the Special Prosecutor unnecessarily. What this government, like any other government, has a duty to do. And we, at the Office of the Attorney General, our job is to advise on position of law and pursue the enforcement of the Constitution and every other law. Even in the pursuit of that, we will have to take a step back and do things properly to ensure sustainability. That is what we have to do. And if we really want the Office of the Special Prosecutor to stay, we should do things right from the beginning. We should do things that are sustainable, not things that are meant to just satisfy a temporary desire and score a temporary point and say that we have done it, when we know deep down our hearts that it has not been done and has not been done properly. We would take every step to ensure that things that ought to be done are done while we still continue with the fight against corruption.
Do you think we need the Office of the Special Prosecutor?
We need it. When what happens is the organization or the person, let me say the person who wants to be authorized. So the institution will submit a list of persons that they want to be authorized, and then we issue executive instrument, or what we usually call a fiat, to the institutions that these persons can go and then prosecute on behalf of the Attorney General. So if you take Iyoko, for instance, it is not every lawyer in Iyoko who has the power to prosecute. The lawyers who have the power to prosecute in Iyoko are lawyers that come and release them in the EI and tell them that these persons are authorized to prosecute. And there is a criteria for even selecting the persons who are authorized to do so.
Okay. So if the OSP were to say, come to you and say they want authorization, that's something the Attorney General will grant them.
Why not? Why not? Why wouldn't we grant them the authorization if they apply for it?
Now, in the same way, the Attorney General can also, because of the importance you attach to the Office of the Special Prosecutor, liaise with them and give them that authorization to prosecute corruption and corruption-related cases, right?
Have you ever listened to the debate is not whether OSP is not interested in coming for the authorization, and it's because the OSP says that it is independent and doesn't require the authorization. That is the issue at the center of it. It's not about why you think if OSP wants to, the office wants to come for the authorization, what does it take? It's a letter you write to us. So the fact that they are not doing it should even prompt you to know that the issue is bigger than coming for authorization.
Well, let's explore this further, bringing in the conversation a bit forward. Joining me now is constitutional lawyer and law lecturer at the head of Department Public Law at UPSA Law School, Albert Kwashiga. I just want to start with your initial reaction. I've been going through this 26-page ruling by the High Court judge, and I would like to quote portions of it to set the tone for the conversation. It says that, just the last few paragraphs, it says the purported exercise of prosecutorial power by the respondent without lawful authorization is unlawful. He cites Article 88 of the Constitution, which states clearly that the Attorney General shall be responsible for the initiation and conduct of all prosecution of criminal offenses, and then goes on to say, consequently, any convictions, if any, secured by the respondent as a result of the purported exercise of prosecutorial powers is hereby declared void. I'd like to start with your initial reaction to the full ruling by this High Court judge.
All right, thank you for having me on this discussion. If I may ask, was that the Deputy AG a while ago?
Yes, please. We engaged him earlier in subsequent bulletins.
Okay, very well. So, well, you asked me about my initial reaction to the ruling, which I have seen and read. I agree largely with what the judge, has come to, and I believe there are good reasons for the judge coming to that conclusion. And so, if you ask me, my initial reaction is that the judge was largely right in his conclusion on this matter.
When you say largely right, do you have any reservations?
Well, I have a few reservations. When I look at the ruling, let's not forget that the ruling was based on an application for judicial review by persons who have been prosecuted already by the OSP. So it was an application for judicial review asking the court to question the legal authority, the basis for the OSP's prosecution of for those people, okay? And the court gave its decision on that. Now, if you look at the ruling, you find out what the application sought from the court, all right? And part of the reliefs that were being sought, looked more like an issue for interpretation. If you look at it closely, I don't have the ruling before me, but if you look at the reliefs that have been sought, one looks like asking, a declaration to the effect that Article 88 and a certain section of the OSP law, for instance, needed to be reconciled and things like that. I thought that, if that issue came up before, the hearing of the judicial review application and it had to be determined, I was thinking that at some point, for instance, the court would have made a determination on whether or not that issue raises a constitutional issue. I did not see that I've not seen anything so far telling me that the issue was properly raised and was argued, by the party. It may well have happened, but it's probably not captured in the ruling. But at the end of the day, the court took the view that it was not an issue for interpretation, because in simple terms, what the application is saying is that the OSP show us the authority for which it's purporting to prosecute people. And the law is quite clear. Even the OSP law tells you that. You need authorization in order to do prosecution. The fact remains that the authorization, is not there at all times. And clearly, that is a violation of statutes. All right. Now, I'm seeing that at that point, the court was not engaged in an issue of interpretation. The court was just saying that, before me, I have an application requesting that you show me your authority. If you have the authorization, show it to the court, and the court will decide on the matter. But the authorization was not there. So as far as the court was concerned, it was a clear violation of statute. And there's a basic principle in our laws. In when a statute is clear and has given certain conditions to be met before a certain power is exercised, right? You have to comply, right? So basically, it's like a condition precedent for having to exercise certain power. So if you need authorization, and that's clearly stated in the OSP law, and the OSP does not have that authorization to show, then clearly that violation of statute cannot be forgiven. And so in one breath, it would have been very worrying for the court to say that, okay, you have violated statute, but let me go on and legitimize what you have done. And so what the court did for me,
we ain't some who team court watch channel so mami and out so jimbre ewa that send us obadi in their dumbi edomania. Yebesan Asia.